Hello, ladies and gentlemen. My name is Isaac Christopher Lubogo, and welcome to International Law. Guys, we're going to have a discussion in terms of the conflict that is happening between Russia and Ukraine, but also particularly between Palestine and Israel. Let's begin with NATO in the context of the Russian war. NATO means North Atlantic Treaty Organization. It's a military alliance primarily composed of North America and European countries aimed basically to counter the Soviet Union during the Cold War and to promote what they call collective defense. So the Soviet Union obviously no longer exists. It was dissolved in 1991, and NATO continues to exist as a defense alliance. Now, the founding act on mutual relations, cooperation and security, which was in 1997, and subsequent agreements play a crucial role in terms of the contextualization of the NATO-Russian relations. And here are some of the agreements and their main points. Number one, the founding act on mutual relations, cooperation and security, which happened in 1997. What happened is that this document was actually signed between NATO and Russia in 1997. And therefore it sought to establish a framework for cooperation and security in Europe after the end of the Cold War. So while not legally binding as a treaty, it outlined several key principles and commitments in terms of, number one, to respect for territorial integrity. Number two, mutual commitment for peaceful and conflict resolution. Number three, enhanced cooperation in areas of common interest such as crisis management, arms control, and even non-proliferation, right? So another document that was important was called the NATO-Russia Council, which happened in 2002. Now this council provides for a forum for consultation and cooperation between NATO members, states, and also Russia on issues of common interest. And its aim was to promote dialogue and address security-related concerns. Okay, another important instrument was what they call the Montreux document on pertinent international legal obligation and good practices for states related to operation of private military and security companies during armed conflict. That happened in 2008. Obviously, again, while not directly between NATO and Russia, this document outlines international legal obligations related to private military and even security companies operating in armed conflict. And it emphasized the need for states to regulate such companies and to ensure that they comply with international law. Okay. Now, these agreements were intended to shape what the so-called post-Cold War relations in terms of promotion of cooperation, enhancing security in Europe. However, their effectiveness has actually been a subject of debate, especially in the context of the development in Eastern Europe, such as NATO's eastward expansion and Russia's actions in Ukraine. So these events obviously raise questions about the interpretation and implementation of these agreements, and they have actually contributed to the tensions in NATO and Russia relations. Yeah? So I'm just laying a background for you so you understand where we're coming from. Now, the founding act on mutual relations, cooperation and security, which happened in 1997, and the challenges it has faced in subsequent years, had substantive effects, as we're going to see. The founding act on mutual relations, cooperation and security, as a document, was signed between NATO and Russia in 1997, and fundamentally it sought to establish a framework for cooperation and security in Europe. So at the end of the Cold War, while not legally binding, as I said, it outlined several key principles and commitments. These are the ones I want us to discuss. Number one, it laid what they call respect for territorial integrity. So both NATO and Russia committed to respecting the territorial integrity of all states and refraining from the threat or use of force against any state. Now remember, there were certain states now, there was an agreement that we're gonna go by this. No more expansion, no more this. Number two, it said mutual commitment to peaceful conflicts in terms of resolution. So the signatories pledged to resolve disputes and conflict through what they call peaceful means and the mechanism provided for by the United Nations Charter. Right? Understand that. Number three, enhanced cooperation. So the founding act also aimed to promote what they call cooperation in areas of common interest, such as crisis management, arms control, and non-proliferation. Okay, now let's comprehend. Now the issue of whether or not and to what extent the United States, particularly NATO as a member, has actually respected in terms of the founding act on mutual relations of cooperation and security between NATO and Russia is really, really a complex matter with varying perspectives. So it is important to note that the situation is subject to interpretation, obviously, and depends on one's viewpoint. So below are some of the issues that I'm going to argue in terms of contextualizing what we're talking about. Now, the biggest challenge with as far as this agreement was concerned was NATO enlargement. Now, one of the major points of contention is NATO's enlargement, particularly its expansion into Eastern Europe, which includes countries that were former Eastern Bloc. So Russia has actually been critical in terms of this expansion, viewing it as a violation of the spirit of the founding act. So from the US perspective, NATO eastward expansion is seen as a natural outcome of the willingness of other European countries in terms of joining the alliance and as an exercise of their sovereignty. But was that part of the deal? Now listen, while the founding act emphasized that NATO would not place substantial combat forces in new member states on a permanent basis, there is debate whether NATO's rational troop presence, for example, constitutes a violation in this commitment. You be the judge yourself. Now, in the context of NATO's eastward expansion and its impact on Russia, there were specific former Soviet or even neutral territories that were engaged or influenced to join NATO. And here are some of the examples. And this is where the problem is beginning. Okay, I'm not gonna give you who's wrong or who's right, but I want you to determine by yourself. For example, there's what we call the Baltic states: Estonia, Latvia, Lithuania. These three Baltic states were part of the former Soviet Union. So they sought NATO's membership to enhance their security and gain protection from potential Russian influence. So after gaining independence from the Soviet Union in the early 1990s, they joined NATO in 2004. NATO's expansion into Baltic was actually seen by Russia as a direct challenge on its sphere of influence. Number two, Poland. Poland was actually a former Eastern Bloc country. It actively, pursued NATO membership as a way of strengthening its security and distance itself from historical ties to Russia. That's another challenge. So Poland becomes a member of NATO in 1999. So its membership was part of the initial wave of NATO expansion in Eastern Europe, and it was a key step in the Eastern enlargement of the alliance. All these things, by the way, remember the agreement, no more expansion. So we are seeing, let's talk about the Czech Republic and Slovakia. Both these countries were actually part of the former what they call Czechoslovakia. Remember, which split into independent states in 1993. So they sought NATO membership to bolster their security and to solidify the integration in terms of Western institutions. So the Czech Republic and Slovenia joined NATO in 1999 alongside Hungary and Poland. Are we seeing what's happening? How about Bulgaria and Romania? These two countries, while not part of the former Soviet Union, were actually former members of the Eastern Bloc and had history with Soviet influence. So Bulgaria and Romania actually joined NATO in 2004, further expanding the alliance presence in the southern Eastern Europe. Now, who's getting uncomfortable here? So the inclusion of these former Soviet or even what they call Eastern Bloc territories into NATO was a source of concern, obviously, for Russia, which perceived NATO's eastward expansion as a threat to its sphere of influence. So Russia argued that such expansion actually violated the spirit of what they call Cold War agreements, post-Cold War agreements. As a result, it strained Russia's relationship with alliances and deepened what they call mutual distrust. So these NATO expansions in Eastern Europe have actually indeed had a significant impact in terms of what they call geopolitical dynamics of the region, contributing on ongoing complexities as far as NATO and Russia is concerned. So the perception of coercing or even bribing these countries to join NATO obviously will vary depending on one's perspective. But these countries largely viewed their NATO membership, I hear, as a means of enhancing their security and even strengthening their sovereignty. Suddenly, I'm going to give you my examples of former Soviet entities that, or what you call other neutral territories that sought NATO's membership or even expressed interest in terms of joining the alliance. We'll begin with, again, Slovenia. Now, Slovenia was part of the former Yugoslavia, so not the former Soviet Union, but it sought NATO membership to strengthen its security and deepen its integration with Western Europe. So Slovenia became a NATO member in 2004 during the same round of enlargement that included the so-called Baltic states. Yeah. Now, other countries like what they called Montenegro. Montenegro was also part of the former Yugoslavia, so it remained neutral for some time after gaining independence from the State of Union of Serbia and Montenegro in 2006. Now, in 2017, Montenegro actually became the most recent NATO member. So its accession to NATO was met with controversy and strong objections again from Russia. So as it's expanded NATO's presence in the Western Balkans. Are we seeing what's happening, guys? How about Georgia? Georgia was actually a former Soviet republic, expressed strong desire again to join NATO after gaining independence. So the country sought NATO's membership as a member in terms of enhancing its security and again aligning with the Western institutions. Yeah? Now, while Georgia hasn't actually really yet attained NATO's membership, it has actually participated in NATO's Partnership for Peace in terms of programs and has even received support from the alliance. So it's in terms of its aspiration for NATO membership has been actually a contentious issue with Russia, particularly in the context of the 2008, the war between Russia and Georgia over South Ossetia. Yeah? Now, how about this other interesting guy called Ukraine? Ukraine basically was actually the largest former Soviet republic after Russia. It expressed interest again in pursuing closer ties with NATO. So in 2010, it adopted what they call a non-aligned status. However, following the 2014 events of Crimea, which some of you remember, and Eastern Ukraine, there was a shift in Ukrainian policy towards seeking NATO's membership. So while Ukraine has not yet achieved NATO's full membership, there's evidence that has actually deepened in terms of cooperation between the alliance, and it's now considered as a key partner, right? So the situation in Ukraine has been a major source of tension between Russia and NATO, contributing to the complex geopolitical landscape as far as Eastern Europe is concerned. Now, the argument I'm propounding here is that these examples have demonstrated that many former Soviet or what they call neutral territories in Eastern Europe have actually been interested in or pursued NATO membership as a means of enhancing the security and solidifying their ties to Western institutions. So these aspirations of such countries for NATO membership have actually been significant factors in evolving geopolitical dynamics of the region and have actually been a source of tension in NATO-Russia relations. Yeah? And obviously, when you argue that in terms of the Ukraine crisis, the annexation of Crimea by Russia in 2014 and its involvement obviously in the conflict in the eastern Ukraine are viewed by many as a direct violation of the founding act's commitment for respecting what they call territorial integrity and sovereignty of all states. So the US and NATO, as a NATO member, has strongly condemned Russia's actions and supported Ukraine's sovereignty. Now, from the US perspective, it is Russia's actions that have actually violated the principles of founding act, according to them. Yeah? Other aspects that we probably want to underscore when it comes to international law is what they call cybersecurity and disinformation. Now, obviously, the aspect of accusations of cyber attacks and disinformation campaigns attributed to Russia have actually created additional strains in the US-Russia and NATO-Russia relations. Some argue that these actions actually go against the principles of cooperation and security as outlined in the founding act. The United States, obviously, along with its NATO allies, has responded with various measures, including sanctions and the attribution of cyber attacks to Russia. Some of you remember that debate very well. Yeah? Another contentious issue is in terms of what they call the military exercises. So both NATO and Russia have actually conducted military exercises near each other's borders, raising concerns about what? Accidental escalation, for example, and the scale and proximity of these exercises that have fueled mutual mistrust. Yeah? The US, for example, is a leading NATO member and has been involved so many times in that kind of exercises. Yeah? And then obviously the sticky one is the Crimea and Eastern Ukraine, that issue. The Crimea and Eastern Ukraine. The US and NATO have actually maintained stance against recognizing Russia's annexation of Crimea and have actually provided support to Ukraine in form of sanctions, in form of military aid. While not a direct violation of the founding act, this support has actually contributed to the tensions between NATO and even Russia. So, my friend, it's important, my friends, to emphasize that the issue involves, as I said, multiple parties complex geopolitical dynamics. Different parties have different interpretations of events in terms of the founding act's provisions, which I think should be our point of entry. While the US and NATO allies assert that actually upholding these principles of so-called founding acts, Russia maintains that its actions are a response to what it perceives as provocations by NATO and its members. Yeah, I don't know whether that makes a lot of sense. I don't know. I don't want to be the judge. I want your conscience in terms of what we're saying to be. So in summary, the question of the US's role in terms of respecting or not respecting the founding act on mutual relations, in terms of cooperations, in terms of security hinges, basically a range of actions and perspectives in terms of interpretations have to be related to what we're talking about in terms of the conflict between Russia and NATO and Russia, yeah, in terms of what happened, yeah. So the issue now, therefore, of territorial integrity and the influence of the US on Russian neighbors, yeah, as well as the perceived shifting of what they call the goalposts in terms of international agreement is a topic of debate in terms of contention, and we need to address some of these issues, yeah. Let's first of all argue in terms of what they call territorial integrity of Russia. Russia has actually expressed that concerns that NATO's, for example, eastward expansion and Western support of former Soviet republics have encroached on what it perceives as a sphere of influence. So from the Russian perspective, this can be seen as a challenge to its territorial integrity in a broader sense. Yeah? So while the founding act on mutual relations, cooperation and security did not actually emphasize respect for territorial integrity, it did not specify the limits of NATO's expansion or preclude Eastern European countries from actually joining the alliance. However, Russia may argue that there was an understanding that NATO would not expand to countries in the former Eastern Bloc. Yeah, that is something that is extremely important. So another aspect is the annexation of Crimea, and the ongoing conflict, obviously, in eastern Ukraine, is actually viewed by many as violations of Ukraine's territorial integrity and have actually contributed to a complex situation. Yeah, that is something that, again, you need to understand. Now, the influence around Russia's neighbors, yeah? I mean, you would be concerned if your neighbors are actually not no more buddies of yours anymore. The expansion of NATO and the European Union into your Eastern European is actually also seen as an extension of what they call Western influence into that region. So this influence can actually encompass what they call political, economic, and even security dimension. Russia has actually viewed these developments with suspicion and actually perceived them as an attempt to diminish its traditional spheres of influence. Yeah, the United States and its allies have supported what they call, I hear, democratic transitions, reforms, and closer ties with these Western institutions in countries that are around Russia. Yeah, so this has sometimes led to what? Disagreements with Russia. And in many of these actions, attempts to diminish its influence in terms of its neighborhood. And that is what is Russia is complaining about. Not so. And then the aspect of what they call shifting of goalposts in terms of the agreement. The perception of shifting goalposts can actually be a source of frustration and mistrust in terms of international relations. Russia has argued, for example, that NATO's expansion and actions in Eastern Europe were not in line with what it's believed to be the understanding of the end of the Cold War. Yeah? Remember that. So the United States and its allies may argue that the founding act and other agreements were not legally binding and that Russia's actions in Ukraine, such as the so-called annexation of Crimea, have fundamentally altered the security landscape in Europe, necessitating a response. Now, listen, the issue of blame in this complex geopolitical context is a matter of debate and subjective interpretation. Different parties obviously see situations differently. Okay, the Americans will look at it differently, so will the Russians. And so the question of whether US or Russia should actually be blamed for the perceived shift in terms of Cold War agreements depends on one's perspective. But again, as I said, the ball is in your hands for purposes of intellectual argument. So it is important to recognize that these issues are actually multifaceted and actually have what they call deep historical and geopolitical security implications. So efforts to address this so-called balance of power or in terms of challenges should actually ideally involve diplomacy, in my opinion, dialogue and international cooperation to mitigate tensions and find common ground among all stakeholders. Okay, now the question is whether we still have that option for them to meet and agree in a diplomatic way. Yeah, I thought they are the pace setters. They should show us Africans as examples, not so. However, despite the intentions set forth in the founding act, tensions instead have actually risen in subsequent years, and particularly due to the following developments. And the biggest tension, obviously, is the so-called Ukraine crisis of 2014. which obviously had to do with the annexation of Crimea by Russia in 2014 and its involvement in the conflict in the eastern Ukraine, strained by NATO's Russia relationship. These actions are seen as a violation of Ukraine's territorial integrity and principles outlined again in the founding act. Now it's like using the same act to enforce, advocacy for things to the detriment of others. Then the aspect of NATO's enlargement. The expansion of NATO, including former Eastern Bloc countries, which were previously again part of the Soviet sphere of influence, have actually been viewed with suspicion by Russia, and Russia has actually raised concerns about NATO's eastward expansion as it perceives it to be a threat to its own security. Even if it were you, I would think you probably have the same concern. Imagine if something was happening in America, what would they say? How about cybersecurity in terms of information welfare? Accusation, again, as I said, in terms of cyber attacks, disinformation in terms of the campaign. Some of you remember what happened during the Clinton era, or the so-called cyber attacks and stuff like that, which led to Trump winning. You remember that? And then the issue of military buildup. The increased military presence and exercises conducted by both NATO and Russia in close proximity to each other in terms has raised concern about accidental escalation that have contributed to a climate of mistrust. And this is likely to again cause more fever, if you like. So despite the challenges and tension, NATO-Russia relationship, in my opinion, has not been completely severed. So the NATO-Russia Council continues to exist as a form of dialogue, although it's now at its low, in the sense that there's a lot of fire that's happening in Ukraine, as many of you are probably aware. Perhaps what is important is that founding act, in my opinion, remains as an important document in the context of Russia-NATO relationships. So, but the practical implementation and adherence of its principles have actually been a subject of debate and contention. So the relationship, in my opinion, continues to evolve and is influenced obviously by a range of factors, including evolving security landscapes in Europe and geopolitical developments. Some can argue that it's a question of what? Of Russia trying to find its space back in terms of a leading superpower, and then it's a question of America trying to be the big brother or the big bully. So all those questions can be argued in terms of that. But again, our entry point is the founding act on mutual relations, cooperation and security, which happened in 1997. That document was signed, as I said, between NATO and Russia and aimed to establish a framework of cooperation and security in Europe after the Cold War. So while we could argue that it was not legally binding as a treaty, it set out principles for NATO-Russia cooperation, such as respect for territorial integrity and mutual commitments in terms of peaceful resolution of conflicts. So despite this agreement, as I said, tensions have risen in subsequent years, even up to the present time of now. Now, breaches, if we're going to argue breaches, Russia-NATO relationship has actually been strained since Russia's annexation of Crimea, in 2014, which violated the principles of territorial integrity in terms of non-interference. So NATO has actually suspended practical cooperation with Russia as a result of that up to the present time, to the extent they're now supporting the war, as you know. NATO-Russia Council, which was established in 2002, provided a forum for consultation in terms of cooperation between NATO members and Russia on issues of common interest, such as counterterrorism, counter-piracy, and even non-proliferation. Now, in terms of a breach, one thing you must understand is that NATO-Russia Council has actually faced difficulties in terms of convening meetings and even maintaining productive dialogue, especially after, again, the Ukraine crisis. And it has actually challenged, been challenged to the extent that it has reached a failure to reach consensus on any issue in terms of the conflicts that are happening right now. When you look at what they call the Montrex document on pertinent international legal obligation and good practices for states related to operation of private military and even security companies during armed conflict, which is the 2008 document. While not directly between Russia and NATO, this document outlined what they call international legal obligations that related to private military and even security companies operating in armed conflict, an issue of relevancy in terms of contemporary conflicts. In terms of a breach, there has been definitely allegations of the use of private securities in terms of security companies with ties, for example, to Russia and America in terms of various conflict zones as well, including Ukraine and Syria. So the involvement of such entities has also raised concerns about accountability and adherence to international law. So that's what we're trying to comprehend in terms of international law. Now, as again, I would emphasize that in the context of the Ukraine crisis, Russia's actions, including the annexion of Crimea, and the support for separate groups in terms of other arguments in terms of Eastern Ukraine have actually raised questions about the compliance here in terms of international law perspectives. So these actions have led to responses such as economic sanctions and political condemnation by the so-called Western powers and organizations, including NATO. Yeah. So it's important to note that that international law is basically a complex, and the assessment of breaches often involves subjective interpretations. So resolutions in terms of mechanisms can actually, include diplomatic negotiations, international tribunals, and the application of what they call sanctions, among other things. And the conflict, obviously, as I said, between NATO and Russia, particularly in the context of Ukraine, continues to be a subject of international legal debate and diplomatic efforts. That is something that you must understand, again, very, very seriously. Now, to drive the point a little bit further, please understand that the situation between Ukraine and Russia, particularly in terms of the conflict that began in 2014, is very contentious. It has raised significant questions regarding international law, and that's where we are coming in. I'm going to argue some of those aspects of what we mean by the international law, and the essentiality in terms of the note that in terms of the situation analysis, in terms of the general principles of international law that apply to conflicts such as the one that we are talking about. But particularly in terms of what we call sovereignty and territorial integrity as a principle, by the way, one of the fundamental principles of international law is the respect for what they call sovereignty and territorial integrity of the states. So in this context, one can argue that international community generally supports Ukraine's claim for its territorial integrity, including Crimea and the eastern regions currently affected by the conflict. Yeah, and obviously the annexation of Crimea by Russia in 2014 is widely regarded as a violation of Ukraine's territorial integrity. We will argue that in other details as well. Now, how about the aspect of what they call the prohibition of use of force? Now, the United Nations Charter prohibits the use of force in international relations unless if it is in self-defense or authorized by the UN Security Council. So Russia's actions, for example, in Ukraine have actually not been authorized by UN, and many may argue that they constitute a breach in terms of this fundamental principle. Yeah? Of course, one will argue whether or not America isn't doing that indirectly. Yeah? Now, how about if you're talking in terms of humanitarian law and human rights law? Yeah? The conflict, again, in Ukraine has also raised concerns regarding the protection of civilians, the treatment of combatants. So international humanitarian law and the human rights dictate the rules in terms of conduct of, for example, hostilities and the protection of civilians during armed conflict. We'll get there when we're arguing Palestinian-Israel issue in terms of the violations, in terms of attacks on civilian population, and in terms of what they call legal scrutiny. Yeah? Okay, excuse me. There is what we call the Minsk Agreement. Yeah? The Minsk Agreement, brokered by the Organization for Security and Cooperation in Europe, for example. These were basically a set of documents that were aimed at finding what they call peaceful resolution to the conflict in terms of eastern Ukraine. So while these agreements have not actually fully succeeded in ending the conflict, they represented some kind of diplomatic effort to address a situation within the framework of international law. Yeah? And then if you argue it in terms of sanctions, one can argue that in response to Russia's actions in Ukraine, many countries, including Western nations, have actually imposed economic sanctions against Russia. And these sanctions are often implemented in accordance with the so-called international law, and they serve as the tool to encourage compliance with international norms. Yeah? That is something that is extremely important. Now, the question of recognition. Now, recognition in terms of the question of recognition is an essential aspect of international law. So in this context, many countries do not recognize Russia's annexation of Crimea. In fact, they consider Crimea to be part of Ukraine in terms of reinforcing the principle of territorial integrity. But again, the question is, it depends on whose eyes you are looking at it. If these guys have actually done a referendum and they have voted overwhelmingly and they say we're okay with Russia, that's another question of debate. So it's important to note that the options in terms of validity of conflict can actually vary depending on the perspective. While many states and international organizations have actually condemned Russia, Russia has argued that it has a right to protect it's the rights of Russian-speaking populations in Ukraine, and has its own legal justification in terms of that mandate. Yeah. So ultimately, the Ukraine-Russia conflict basically is a complex, as I said, still ongoing, and has significant implications in terms of international law and in terms of principles governing the conduct of states in international systems. So when you're arguing it in terms of legal interpretations and positions, we may continue to evolve, the situation will continue to evolve, and therefore, as it unfolds, well, we may have to invoke international institutions in terms of legal mechanisms to adapt to address these particular issues. Yeah, I'm going to give you some specific aspects that are related to Ukraine-Russia conflict from an international perspective. I would like to argue it in terms of, again, what they call self-determination. Now, the principle of self-determination is a fundamental concept in international law, and basically it allows people the right to determine their own political status. Yeah, in this context, some have argued that Russia-speaking population in Crimea and in eastern Ukraine should have the right to determine their political future. Not so. While others contend that Russia's actions violate Ukraine's sovereignty. Yeah. And then if you are to argue it in terms of the annexation again, the annexation of Crimea, Russia's annexation of Crimea is a key issue in terms of the conflict, and perhaps that's the beginning. International law generally prohibits acquisition of territory by force as codified under the United Nations Charter. The international community largely views Russia's annexation, as I said, as a violation of this principle. Obviously, these laws were put in place after the world had been divided anyway by these so-called superpowers. Then how about the responsibility to protect, what they call the RR2P? The responsibility to protect is a doctrine of international law that holds states responsible for protecting their populations from mass atrocities. And it can justly, and it can justify international intervention when, for example, a state fails to do so. So some argue that the situation in Ukraine, particularly the treatment of certain minority groups, may actually trigger what they call the RRTP doctrine, as explained. Now, in terms of legal status of separate entities, the self-declared, for example, Donetsk People's Republic and Luhansk, the People's Republic, in terms of eastern Ukraine, have actually sought recognition as independent entities. So international law does not generally recognize such entities as independent states without the consent of the parent state, which in this case is Ukraine. However, some nations have actually provided for what they call de facto support to these entities, while others see them as a product of Russian intervention. Yeah, so that is something that you may also want to comprehend from that perspective. Now, if you are to argue it in terms of what they call International Court of Justice, the ICJ, Ukraine basically filed a case against Russia at the ICJ in 2017, alleging for violations of what they call International Convention for the Suppression of the Financing of Terrorism and the International Convention on the Elimination of all forms of racial discrimination. The case basically was an example of how international legal mechanism can actually be used to address the aspects of the conflict. Yeah, and then if you argue it in terms of what they call war crimes and accountability, then one would argue and say that allegations in terms of war crimes and human rights violations have actually been raised by both sides of the conflict. So the International Criminal Court, what they call the ICC, can actually investigate and even prosecute individuals for war crimes and crimes against humanity. So the argument here is that while Ukraine is not, a party to the so-called Rome Statute, the ICC's jurisdiction can extend to crimes committed on Ukrainian territory if they involve, the nation of the state that is a party to the ICC. Yeah. So it's important to understand, my friends, that the Ukraine-Russia conflict is tricky, complex, and evolving with multiple legal dimensions. In terms of international law, as I say, it provides a framework in terms of addressing many issues that have been raised by the conflict, and it's up to international community in terms of including organizations like the UN to continue working towards a peaceful and legal resolution of the situation. Yeah. Now, while Russia concerns about NATO's expansion are actually a matter of geopolitical dispute, a legal justification for its concern could actually be framed as follows, in terms of referencing specific breaches and also utilizing what they call international law principles. We could argue from Russia's point of view that number one, violation of the Budapest Memorandum, which was a 1994 memorandum. In terms of legal rationale, the Budapest Memorandum signed by Russia, the US and the United Kingdom provided security assurances to Ukraine in exchange for its voluntary nuclear disarmament. It included commitment to respect Ukraine's territorial integrity and refrain from using force against Ukraine. In terms of the breach, Russia argued that NATO's eastward expansion and the subsequent support for Ukraine's NATO aspirations violated the spirit of the so-called Budapest Memorandum. Yeah. So in 2014, Russia claimed that its action in Crimea were actually necessary to protect Russian-speaking population and actually prevent Ukraine's entry into NATO. Yeah, and by way of impact, Russia has actually maintained that these actions were taken in line with the Budapest Memorandum to safeguard its interest and counter what it viewed as a breach by the United States. Yeah. Now let's also look at it in the context of the application of the United Nations Charter. Yeah. Now, in terms of the ratio discendi, the legal rationale, the United Nations Charter basically is the foundation document of international law that actually prohibits the use of force in international relations except in cases of self-defense or when authorized by the UN Security Council. Yeah. Now, by way of breach, Russia argued that NATO's eastward expansion and support for countries seeking NATO membership could actually be seen as a challenge to Russia's security and interests, which in turn Russia saw as a violation of the principles of the UN Charter. Yeah? So in terms of impact, Russia contended that its actions in Crimea and eastern Ukraine were actually aimed at protecting its security interests, including the Black Sea Fleet. Access to Crimea in response is what is perceived as a provocation by actions by NATO. Yeah, so that's something that again we need to understand. Now, if we're to argue again in terms of the concerns about territorial integrity and sovereignty, we have to argue in terms of the legal rationale. Now, international law underpinned by the UN Charter underscores the importance of respecting territorial integrity and sovereignty of states. Now, in terms of a breach, Russia asserted that NATO's expansion, particularly in terms of inclusion of former Eastern Bloc countries and former Soviet republics, challenged Russia's sphere of influence and was perceived as an encroachment on its sovereignty. Yeah, and by way of impact, Russia's actions in Ukraine, including the annexation of Crimea and support for the separatist groups in eastern Ukraine, were viewed by Russia as a response to protect its interests and prevent further encroachment on its spheres of influence. Yeah. Logical, not so. Logical, but perhaps one of the problems we have is that we're influenced by what? Western media, yeah? But it's important for you to have this discussion. So, it's important to note that the legal justifications provided here are basically presented from in my mind, a logical perspective, and may not be universally accepted, but in terms of international law. So, this argument of NATO-Russia, as I said, revolves around conflicting interpretations of legal and geopolitical principles and international legal debates, and these matters remain complex and contentious. So, as I said, you may have different legal perspectives in terms of diplomatic efforts that are ongoing to address some of these challenges. Yes? Now, continuing from legal justification in terms of Russia's perspective regarding NATO's expansion, there will be an argument that there is an argument in terms of what they call the preservation of what they call strategic interests in Crimea, yeah? And the legal rationale here being that states have actually a legitimate interest in safeguarding their strategic military assets and even critical interests in their vicinity, which is very common. You saw what happened in the Cuban crisis, yeah? What America, to use the Uganda phrase, Vagina Gobuto, yeah? So the breach, Russia argued that the presence of the Black Sea Fleet in Crimea was strategically vital for its defense and has been a long-standing arrangement between Russia and Ukraine. Yeah. Now, in terms of impact, Russia's annexation of Crimea, although widely, criticized by the so-called international community, was justified by Moscow as a move to secure its strategic interests, especially in maintaining control of the Black Sea Fleet's access to the Black Sea. Yeah. Another aspect that you may want to argue is in terms of concerns about encirclement, which in my opinion again has a lot of sense in one way or the other. I mean, legal rationale. States have a legitimate right, for example, to protect their security and defense interests from perceived encirclement by foreign military alliances. Yeah, just imagine even if were your house is surrounded. In terms of breach, Russia contended that NATO's eastward expansion, when seen in conjunction with other geopolitical developments, created an environment in which Russia felt surrounded and even encircled. Yeah. So the impact in terms of Russia's concerns about that encirclement were used to justify, actions such as the build-up of its military capabilities along its borders with NATO member states. In my opinion, I think that makes some good sense. So, my friends, it's very crucial to recognize that these legal justifications were actually asserted by Russia to explain its actions in terms of NATO's expansion. So, international law and the interpretation of these agreements can highly be contested in the realms of geopolitical But these arguments again remain subject of ongoing debates, as I say. So with various legal and even political perspectives in play, different parties, for example, NATO or even Western countries, have actually presented what they call contrasting legal interpretations and actually raised concerns about Russia's actions in response to these perceived threats. So the argument here being that diplomatic efforts should and maybe will continue in terms of trying to demystify the complex disputes that are found in terms of that. Now, let's talk about the Israel-Palestinian conflict. Israel-Palestinian conflict. First of all, for starters, Israel-Palestinian conflict is a protracted and complex conflict with deep historical roots in terms of international law, and it plays a significant role in terms of framing and addressing the issues at stake. So I'm going to give you a history of sorts in terms of the conflict from an international perspective. Yeah? Historically, let's argue this. Yeah? Let's talk about what happened in terms of the pre-20th century. Listen, the religion now known as Israel and Palestine has actually been historically inhabited by various groups, including Jews and Arabs. Yeah? So, in terms of the so-called Ottoman Empire, who ruled the area for centuries. Yeah? Now, there's what they call the Balfour Declaration, which happened in 1917. During World War I, the British government actually issued the Balfour Declaration, which expressed support for the establishment of national home for the Jewish people in Palestine. Yeah? So this declaration played a role in shaping the future of the region. We're beginning to see how things begin to work out. So the British mandate in terms of 1920 to 1948, after World War I, the League of Nations granted Britain a mandate to administer Palestine. So during this period, Jewish immigration increased, leading to tensions between Jewish and even Arab communities. Yeah? Now listen, what happened after post-World War II? Yeah? Under post-World War II, we need to talk about what we call the United Nations Partition Plan, which happened in 1947. Now, the United Nations proposed a plan to partition Palestine into separate Jewish and Arab states, with Jerusalem under international administration. So this plan was accepted by the Jewish leadership, but rejected by the Arab leaders. Think about that. Now, in 1948, Arab-Israel War, remember that? After the declaration of the State of Israel in 1948, neighboring Arab states invaded, leading to the so-called First Arab-Israeli War. And the conflict resulted in Israel expansion and Palestinian displacement. Are we seeing where we're coming from? Now, some of the key legal principles, international legal principles that I would like us to argue here were, first of all, the United Nations Resolution 242 of 1967. This resolution called for Israel's withdrawal from territories captured in the Six-Day War in 1967 and for achieving a just settlement for the refugee problem. Yeah? And then United Nations Resolution 338 of 1973. The Resolution 338 affirmed Resolution 242 and called for an immediate ceasefire and negotiation for a peaceful settlement. Yeah? Are we seeing? Now, Palestinian self-determination became another issue. International law recognizes the principle of self-determination for peoples, including the people of Palestine. So the right in terms of self-determination is enshrined in the United Nations Charter and other international agreements. Okay? Now, let's talk about what happened post-1967 conflicts. Now, particularly after that, we will address what we mean by the Israel settlements. Now, the establishment, for example, and expansion of Israel's settlements in the West Bank and Eastern Jerusalem are the major points of contention here. The construction of settlements is viewed by the international community as a violation of the Fourth Geneva Convention, which prohibits the transfer of an occupying power, civilian population into occupied what? Territory. That is super, super important. Yeah? And then the so-called Palestinian territories. Now, the West Bank, Gaza Strip, the Eastern Jerusalem are considered occupied territories under international law. So Israel's presence in these areas is subject of significant legal debate and controversy. That is something you must contemplate over. And then we have what they call the Oslo Accords, which happened in 1993 to 1995. The Oslo Accords were a set of agreements between Israel and Palestine Liberation Organization, PLO. that aim to establish a framework for future resolution of conflicts, leading to the creation of Palestinian Authority. However, the cause did not result in a final resolution. Now, we have to argue this in terms of what is happening today. Yeah? Now, the recent developments, particularly in 2017, when U.S. recognized Jerusalem, U.S. recognition of Jerusalem happened, and the United States recognized Jerusalem as Israel's capital, sparking international controversy, and many countries view the status of Jerusalem as a final status issue to be resolved through negotiations. And then how about the issues of Hamas-controlled Gaza, which is the question of debate even as we speak now. The Gaza Strip is controlled by the Palestinian group Hamas, while the West Bank is governed by the Palestinian Authority. So this political division further complicates the efforts towards a unified Palestinian kind of leadership. And if you have to argue it in terms of the Israeli-Palestinian peace process, for example, we could simply say that the efforts to achieve a comprehensive and even negotiated settlement to the Israel-Palestinian conflict have actually faced significant challenges, including issues related to borders, refugees, security, and even the question of Jerusalem. Okay, now please understand that the Israel-Palestinian conflict remains a deeply entrenched and multifaceted issue, and international law plays a crucial role in shaping the discourse and even potential solutions. So the conflict has actually been the subject of numerous United Nations resolutions, for example, international court cases, and diplomatic efforts aimed at finding a peaceful and just resolution on the issues at hand. That is extremely important even as we debate. I'm going to try to go through this again in brief so that we can comprehend this kind of conflict, so that when we apply international law, we will know exactly what we're talking about. In brief, as far as the Israel-Palestinian conflict, please understand that Israel-Palestinian conflict has a long, as I said, and complex history marked by various events and actions and breaches of international law. And as I said, I'm going to provide chronologically some of these highlighting moments that are associated with international legal aspects. I'll begin, as I said, with the pre-20th century. Remember that? And if you're arguing that in terms of the pre-20th century, we'll comprehend and understand that there are arguments in terms of what they call historical claims. The region known as Palestine was historically, as I said, inhabited by diverse communities, including Jews and Arabs. Different historical claims and ownership may dispute the existence, but those are some of the theories that are propounded. Now, what happens under the 20th century, we see the emergence of the so-called Balfour Declaration, which is 1917, remember? And the legal aspect there is that the Balfour Declaration issued by British government during World War I, which expressed support for the establishment of a national home for the Jewish people in Palestine, which laid the groundwork for this future development. So everything is taking shape now, And then the British mandate of 1920 to 1948. In terms of the legal aspect, the League of Nations, for example, granted Britain the mandate to govern Palestine, and the mandate actually incorporated the Balfour Declaration in terms of the provisions. And then the issue in terms of the impact, the Jewish immigration to Palestine increased, leading to tensions again between Jews and Arab communities. In spite of the fact that history has it that they all came from one guy, Abraham, not so. And then the issue of the post-Cold War II, again, in terms of the argument of United Nations partition plan, particularly in 1947, where it was argued that the legal aspect argued that the League of Nations proposed a partition plan that aimed to increase separate Jewish and Arab states in Palestine with international administration of Jerusalem. And the impact here was that the plan was accepted by the Jewish leadership but rejected by Arab states and Palestinian leaders. And this rejection set a stage in terms of the future conflicts that we are seeing today. And then obviously we can then come down to the 1948 Arab-Israel War, where we're arguing that in terms of the legal aspect, the first Arab-Israel War followed the declaration of the State of Israel in 1948, and the conflict resulted in Israel expansion and displacement of Palestinian refugees. And this impact, of course, was created a significant number of refugees, which remains a central point of contention even up to today. And then if we talk about the post-1967 conflicts, then also the 1967 Six-Day War, if you remember, in terms of the legal aspect, what happened is that Israel basically captured the West Bank and Gaza Strip and Eastern Jerusalem during this Six-Day War. Yeah, and the legal issue here is that Israel's occupation of these territories became a critical international law issue, even up to today. Yeah, to the extent that governors still preside, selected or whatever, selected governors or perhaps Israel-based governors are still governing that. Now, in terms of the United Nations resolutions, especially 242 and 338, the resolutions called for Israel withdraw from occupied territories and a just settlement of refugee problem based on international principles. And the resolution basically laid the foundation for what they call future negotiations, but these were not fully implemented. And then if you argue in terms of 1993 to 1995, we talk about what they call the Oslo or the Oslo Accords. In terms of these accords established a framework for negotiations between Israel and the Palestinian Liberation Organization, the PLO. And the outcome in terms of these agreements led to establishment of what they call the Palestinian Authority, but did not result in a final resolution. Yeah, and then if you talk about in terms of post-2000, then you may want to look at it in terms of the Israel settlements. Yeah, in terms of the legal aspect, we could argue and say that the construction and expansion of Israel settlements in the West Bank were seen as a violation of the Fourth Geneva Convention in terms of prohibition on transferring civilian population into occupied territories. Yeah, and in terms of settlement, it was argued that settlements have actually been a major source of legal dispute and conflict even up to today. Yeah. Now, if we're looking at it in terms of Palestinian territories, we could argue as well, when we're arguing in terms of legal aspect, that the West Bank, for example, the Gaza Strip and the East Jerusalem are considered occupied territories under international law. So that's something that is extremely important for you. If you're arguing in terms of legal status, then the legal status of these areas, as well as the status of refugees and borders, have actually been contentious issues which warrant immediate attention. And then obviously recognition of Jerusalem in 2017 created also another challenge, in the sense that the US recognized Jerusalem as Israel's capital. And the move viewed by many as disregarding the status of Jerusalem as a final state issue for negotiations. Yeah, and then the issue of impact recognition led to international controversy, as I said, and even complicated the peace process even more in terms of what even President Putin had actually said that America has probably failed to understand. So these chronicle events highlight those key moments in terms of the Israel-Palestine conflict, and the association in terms of international legal aspects, and the persistent issues that have actually contributed to the ongoing conflict in terms of international law, which continues to play out even up to today. Yeah. So the question perhaps would be, who are the real owners of the land, in the region known as Israel and Palestine? That becomes a question of historical debate and contention, and basically different perspectives actually exist. So to provide some historical context, it's important to understand that the region has actually been inhabited by various peoples, as I said, including Jews, Arabs, and other, others for a long time, for millennia. Yeah. So the historical claims and rights of these different groups to the land are complex and multifaceted. But we'll give you an overview in terms of perhaps let's argue it first of all from a Jewish perspective. Yeah. If you're arguing in terms of a Jewish perspective, ancient Jewish presence, for example, historical data shows that has been Jewish presence in the region for thousands of years. Jerusalem, for example, has deep historical and religious significance in terms of Judaism, with the Western Wall being one of the holiest sites, as it were. Yeah, and then we could also argue in terms of what they call ancient and medieval Arab presence. Yeah, in terms of the Arabs and various Arab communities have actually lived in the region again for centuries, alongside other communities, including Jews and Christians. So Arab Muslims rule was actually established in the area even after the Muslim conquest in the 7th century. And that's something also important historically to verify. Yeah. And then in terms of what we call the Ottoman rule, you have to understand that the Ottoman Empire, for example, ruled over the region for centuries, from the early 16th century until the end of the World War I. So during this time, as again, various communities lived in the area under the Ottoman, administration. Yeah. And then if you have to argue that in terms of the 19th century, in terms of what they call the Jewish immigration, in the 19th century there was an increase in Jewish immigration to the region, driven by factors such as religious and nationalist motivation, and Jewish communities, agricultural settlements and cities developed, particularly in the late 19th and early 20th century. Yeah, and then after that, we could argue it in terms of what they call the British Mandate, particularly in terms of 1920 to 1948. After World War I, the League of Nations granted Britain a mandate to govern Palestine. Yeah, so during this period, both Jewish and Arab communities lived in the area, and the mandate actually incorporated the so-called Balfour Declaration to support for the so-called national home for the Jewish people. Yeah, and obviously, no doubt that historical coexistence and tensions have emerged, and the region has actually a history of both peaceful coexistence and periods of tensions and conflict between different communities. And these complexities actually reflected in the region's history, even as of what is happening today in 2023. Yeah. So, my friends, it's very, very important to recognize that these historical claims to the land are deeply intertwined with religious, cultural, and even political factors. So the question of ownership becomes even further complicated by the fact that the concept of national states, as understood in terms of modern sense, was not prevalent in the region until the 20th century. Therefore, the historical context is often cited differently depending on one's perspective. Yeah, and important to note also is that modern international discussions on the Israel-Palestinian conflict are actually concerned with political and even legal aspects in terms of territorial disputes, and in terms of also refugees' rights, and in aspects in terms of self-determination, and even other factors. So, while these historical claims are actually significant, the search for a peaceful and even just resolution to the conflict often requires a focus on contemporary international law and diplomacy. Yeah? Now, excuse me, let's argue it in terms of a Palestinian perspective. Now, the historical claim to the land in terms of the region now known as Israel and Palestine is rooted in their own, standing presence in the area. And historical ties to many Palestinians have actually put in terms of claim over that land. Historically, it could be argued that Palestine, for example, like other peoples in the region, have a deep historical connection to the land. Yeah, and for centuries, Arabs, for example, and indigenous communities have actually inhabited what is now Israel and Palestine. Yeah, I will give my remarks in terms of who is the cause of the problems. In my opinion, it's clear. If you're following the history, then you know who's the source of trouble. Yeah. Now, historical data shows that Palestine communities, both Muslims and Christians, have actually lived in this region for generations. In terms of families, in terms of communities, which have deep roots in the land and traditions and customs and even practices that have actually been passed down through ages. Yeah. Now, many Palestinians can actually trace their lineage in the region back for centuries. So if you argue in terms of historical maps, for example, documents and records, they demonstrate the presence of Palestinian communities and settlements in that area. Yeah. Perhaps what is also true is the impact of the so-called Ottoman rule. Yeah. And what happened is that during the Ottoman rules empire, which lasted for almost several centuries, the Arabs and Palestinian population remained in the region. So while the Ottoman Empire was actually an overreaching political authority, local communities, including Palestine, continued to inhabit and even cultivate the land. Yeah. So if you have to argue that in terms of the legal and administrative structure of the Ottoman Empire, what happened is that this allowed for some kind of coexistence of diverse communities, including Arabs and Jews on the land. And if that is true, then you wonder why the struggle still continues. But then perhaps, in my opinion, without throwing any bias, is the so-called British Mandate period. Yeah, to me that's a little bit of that colonial thingy that comes up. It happens in Africa. Many countries that wouldn't be what they are were amalgamated or forced to. So the British Mandate, especially after World War I, brought about so much change in the region. The so-called Balfour Declaration, which expressed the support for a national home for the Jewish people in Palestine, issued by the British government. Now I'm wondering, how about if they had done it also for the Palestinian, one or the other? So during this mandate period, both Jews and Arab communities continued to live in the region, and that's when the tensions of these communities escalated over time. Yeah, and that's a big problem. Yeah, so Palestinians obviously would argue that their presence and attachment to the land has actually remained strong before even after the so-called British Mandate, despite various challenges and conflicts. Yeah, and the Palestinian narrative obviously emphasizes that historical coexistence and shared heritage of Arabs, Muslims, Christians, and Jews in regions, despite periodic tensions as well. So all these components are actually seen in that perspective. So we could argue that from the Palestinian perspective that the historical claim to the land is based on a long-standing presence, as I said, in terms of attachment, in terms of cultural heritage. So Palestinians argue that they have actually deep historical roots in the region, and their connection to the land is a fundamental aspect of their identity. So this perspective obviously plays a very central role in terms of the Palestinian quest for self-determination, recognition, and a just resolution to the Israel-Palestinian conflict. Yeah. So again, just for purposes of balance, from an Israel point of view, the historical claim to the land in the region now known as Israel and Palestine is based on a combination, again, of historical and religious and political factors. And we're going to argue that from a little bit of an Israel perspective to shed some light. Their connection, the Israel point of view, is connected in terms of historical Jewish connection. Yeah, Israel, through ancestors of modern-day Jews, have a deep historical and religious connection to the land, and the region is often referred to as the Promised Land in the Hebrew, the Old Testament. And those of you who are good Bible readers, you know the argument in terms of the Promised Land when he told Abraham, "I'm going to take you to the Promised Land," right? And that becomes dicey when you argue it in terms of philosophy and even theology. So historical data and archaeological evidence indicate that Jews have lived in the area for thousands of years, with continuous presence in Jerusalem and other parts of the land. Yeah, and that becomes again a question of serious debate. So the historical and religious significance of the land is central to the Jewish faith and identity, with Jerusalem being a holy city for the Jews. Yeah, that's another question. And then there's an argument in terms of a return to the homeland. Yeah, those of you who know what they call the Zionist movement. The Zionist movement, which emerged in the 19th and 20th century, sought to reestablish a Jewish homeland in the land of Israel, which was then under the Ottoman and British rule. Yeah, again, we're seeing the influence of the British and the Ottoman. Now, Jewish immigration to the region increased during the late 19th and 20th century as Jews sought to refuge and fulfillment of their Zionist aspirations. So Jewish communities and towns and agricultural settlements were actually established in the land. And if you argue that in terms of legal foundation for that particular concept, then you have to remind yourself of the Balfour Declaration of 1917, which was issued by the British government during World War I, expressed support for the establishment of a national home for the Jewish people in Palestine. Yeah, and this declaration laid groundwork for the establishment of the State of Israel, as we know it today. Obviously, again, the fact that the British mandate for Palestine, which followed World War I, incorporated the Balfour Declaration's provisions and facilitated Jewish immigration and and land acquisition in the region. I'm told there was even a desire for making Uganda as a land for the Jews. Now, the 1948 Declaration of Independence, again, where the state of Israel was actually declared independent in 1948, followed the United Nations acceptance of UN's partition plan, which called for establishment of separate Jewish and Arab states in Palestine. Yeah. So Israel Declaration of Independence actually emphasized historical and even religious connection to the Jewish people in terms of ownership of this particular land that we're talking about. But no doubt that we're seeing two sides of the story, very strong arguments, very strong historical facts, very strong logical conclusions. But who to blame? Let's see. In terms of modern Israel today, from the Israel perspective, the state of Israel, for example, was established as a homeland for Jews, many of whom had actually experienced centuries of persecution and discrimination in various parts of the world. We all know a little bit of that story, the Hitler-like stories and the likes. So Israel argue that the establishment of a Jewish state in the land was actually a response to historical injustices and the recognition of the Jewish people's right to self-determination and security, which I think is a strong point. Yeah, and from the Israel point of view as well, the historical claims to the land is rooted, as I said, in long-standing historical and religious connection of Jews to the religion, and the legal foundation established during the British mandate That's a dicey one. And the recognition of the Jewish people's right to a homeland. Yeah, and the perspective basically is central to Israel's national identity and its quest for security and self-determination, which is okay in terms of really fairness. Yeah. Now, the Israel-Palestine conflict has actually been marked by a series of international breaches, and often involving actions by both sides. And I'll give some chronological review of some of these breaches for purposes of underscoring breaches in terms of international law. In terms of the pre-1948, the British mandate, in my opinion, is the first one. The British mandate for Palestine from 1920 to 48 was intended to prepare the territory for self-governance. However, the British administration faced criticism for not implementing the Balfour Declaration in terms of the provisions in a balanced manner, leading to tensions between Jews and the Arab communities. And my problem is, to me, that's problem number one. That, to me, is super problem number one. Okay? And then what happened? Then super problem number two is 1948 Arab-Israeli War. Yeah? Remember that? In my opinion, the issue of Palestinian displacement during and after the 1948 war, known as the Nakba, or what they call the catastrophe, by Palestinians, hundreds of thousands of Palestinians were actually displaced from their homes, and this resulted in significant refugee problem, with many Palestinians not even allowed to return to their home. That, to me, is again another serious problem. If these British and Americans wanted to solve that problem, I think that would have come out very strongly even from the word go. And then 1967, the Six-Day War, the aspect of the occupation of the Palestinian territories. After the Six-Day War, Israel occupied the West Bank, Gaza Strip, and even East Jerusalem. The occupation was a breach of the Fourth Geneva Convention, which prohibits the transfer of an occupying power's civilian population into occupied territories. That, to me, is problem number three, yeah, in terms of the conflict. And then let's argue in terms of 1967, post-1967, yeah? Israel settlements, the continued construction and expansion of Israel settlements in the West Bank and East Jerusalem were seen as violations of the Fourth Geneva Convention, which prohibits such transfers as regarded as illegal by much of the international community. To me, again, that's a dicey one, yeah? These are things that, they are real. I mean, we all have sympathy for all these guys, but we have to be fair. Let's call a spade, and not a big spoon. And I'm not being biased in any way. How about the UN resolution? UN resolution 242 and 338. These resolutions calling for Israel withdraw from occupied territories were not fully implemented, leading to, protracted occupation. Yeah? How about the issues to do with what they call the first Intifada, which is 1987 to 1993. In terms of Israel response, during the first Intifada, there were allegations of excessive use of force by Israel security forces, resulting into casualties among Palestinian civilians. Yeah? Those are dicey things, guys. We cannot ignore them. How about the second Intifada, the one of 2000 to 2005? Yeah? In terms of violence and human rights violation, the second Intifada was marked by violence on both sides, with allegations of human rights abuses and war crimes committed by Israel forces and Palestinian militants. Note the words I'm using: Israel forces, IDF, and Palestinian militants. And I'm not being biased in any way. And then how about the issue of the so-called Gaza blockade? Yeah, which is the question of debate today. Gaza blockade. The blockade imposed by Israel and Egypt on the Gaza Strip has actually been criticized as a form of collective punishment, and has resulted in severe, humanitarian conditions for the population. And those of you who have been to Gaza, you probably know what I'm talking about. How about the so-called Operation Cast Lead, which happened in 2008 to 2009? Yeah, in terms of the allegations of war crimes, Israel's military operation in Gaza, known as Operation Cast Lead, led to allegations of war crimes, including disproportionate use of force and attacks on civilian areas. Talk about what's happening today. We'll get there. Yeah? How about in terms of Operation Protective Edge, which happened in 2014? Yeah? In terms of human rights violations. During the Operation of Protective Edge, there were allegations of human rights violations and war crimes on both sides. Both sides, please understand that. Both sides, with concerns about high number of civilian casualties. It's the same thing that's happening today. So if you have to understand what's happening today, you must understand what happened yesterday, and that's why I'm laboring. How about the annexation plans of 2020, where Israel annexation plans in 2020, Israel announced plans to annex parts of the West Bank. Yeah, annexation of occupied territories is considered a violation in terms of international law, including the Fourth Geneva Convention. So, in my opinion, what is important to note is that these breaches of international law have actually contributed to the ongoing complicity of Israel-Palestinian conflicts and have actually been the subject of international criticism and diplomatic efforts to address the situation. So it is important to note that the conflict is marked by a multitude of legal and political disputes, and different parties in terms of that have their own perspective on these issues. It's very important, my friend. We cannot run away from the truth. The truth has to be told as it is. I'm going to talk about a few other breaches in terms of the development of the conflict between Israel and Palestine. There was also the so-called Gaza protest, the 2018, up to now, by the way, because what's happening now is terrible. There's excessive use of lethal force. You saw what happened, yeah? Israel forces have actually faced criticism for their use of ammunition during protests at the Gaza border, the use of lethal force against Palestinian demonstrators that has actually resulted in numerous casualties, including many deaths and injuries. Yeah, and the fact that Israel perhaps is probably the fourth biggest army with a nuclear arsenal and fighting Palestinians, which have virtually no army like the Gaza people, you could imagine the balance of power there. So why don't we talk about normalization of these agreements? In recent times, it could be argued that Arab states, including the United Arab Emirates, Bahrain, Sudan, Morocco, have actually established diplomatic relations with Israel, making it a significant shift in terms of regional dynamics. But some view these agreements as a breach of Arab consensus in terms of supporting the Palestinian cause. Yeah. Then, in terms of the Jerusalem tension, which is again another serious issue, the issue of Jerusalem tension, the issue of the status of Jerusalem, ongoing disputes over the status of Jerusalem, particularly or the situation of what they call the Al-Aqsa Mosque, the old city, have actually led to confrontations in terms of restrictions and in terms of clashes between Israel security forces and even Palestinian worshippers. Yeah? How about if you argue in terms of ceasefire violations? How many times has that happened? Periodic conflicts, especially in Gaza, such as 2012, 2014 conflict, even before you begin urging 2023 now perhaps it's the worst. But even before you begin arguing now, this has led to several allegations in terms of international law, including disproportionate use of force and even attacks on civilians. Yeah, and then the aspect of Israeli security barriers. Yeah, especially Israeli West Bank barriers. Yeah, the construction of security barriers in the West Bank has also raised concerns about its impact on Palestinian communities in terms of access to resources, in terms of territorial contiguity. And the International Court of Justice issued an advisory opinion in 2004 stating that the barriers construction in occupied Palestinian territory violated international law. These are issues, my friends, that you as an international law student perhaps, or person who is interested in it could comprehend. So the Israel-Palestinian conflict remains highly complex. The contentious issues of ongoing dispute breaches in terms of international law, political challenges, it has been characterized by so much adverse perspectives and multitude of legal and diplomatic complexities that continue to shape the conflicts in terms of the dynamics today. Yeah. Now, if we're to argue in terms of more developments, in terms of the breaches, we could argue in terms of still those continued settlement expansions that I just talked about. I just laid out super clear for you that there is still ongoing expansion in terms of West Bank and East Jerusalem, which has actually attracted a lot of criticism as a violation of international law. The construction of new settlements, for example, and the expansion of those that are existing, resulting in displacement and restricted movement of the Palestinians. And these are things, my friends, that may make these guys a little bit uncomfortable. And then the violence, of course, in Jerusalem, particularly the one that happened in 2021. Yeah, the Jerusalem clashes in 2021, the tensions and the clashes in East Jerusalem, for example, particularly around the what they call the Al-Aqsa Mosque, that led to violence and the use of force and evictions of Palestinian families in the Sheikh Jarrah neighborhood of Jerusalem, fueled a lot of international concern and criticism. Yeah, and then in terms of the Gaza conflict, which is 2021, but also majorly, I don't know what to say about 2023, but even if I argue in terms of 2021, The Gaza conflict, especially May 2021, in Gaza and Israel, resulted in significant civilian casualties in terms of infrastructure damage, allegations of breaches of international law, including violations of law of armed conflict. It drew international calls for ceasefires in terms of investigations into potential war crimes. Yeah, and even in terms of legal actions and ICCC investigations. Yeah, and also if you're arguing in terms of international criminal court investigations, then ICC basically announced that it was actually opening an investigation into possible war crimes in the Palestinian territories, and Israel has actually challenged the ICC's jurisdiction, while Palestinians view this as a significant legal development. Even today, Israel now, they've done the same thing, and Israel has actually said, wait a minute, don't even waste your time going there. And the aspect of suspension of annexation, in terms of plans in 2020, Israel basically announced that it was actually suspending its plans to annex parts of the West Bank, and a decision that followed international criticism that concerns over violations of international law as well. So those are issues that, my friends, when you're arguing and you're looking at the complex that we're talking about, you must understand it from a broader perspective. You have to comprehend it that this is not something that started today. And this conflict, as I said, continues to evolve. It's marked by ongoing disputes. There are breaches of international law. There are complex dynamics that involve. So the developments reflect a deep-seated and multifaceted nature of the conflict, which remains, as I said, a subject of international concern and diplomatic efforts to achieve a just and lasting solution, in my opinion, would be highly, highly, highly welcome. I know there are quite lots of efforts that have come from quite a number of players, maybe from America, particularly in terms of trying to create an undertaking, but from even some Arab countries. But let's argue some cases and in terms which have presented what international legal principles that are played out in the conflict as it has been developing. We want to start with one they call the International Court of Justice Advisory Opinion on legal consequences of the construction of a wall in occupied Palestinian territory, which happened in 2004. Yeah, and in terms of case, in 2004, the ICJ issued what they call an advisory opinion in response to a request from the UN General Assembly regarding the legality of the construction of an Israel West Bank barrier. And the principles particularly that were engaged here as far as international law was concerned is that the ICJ concluded that the construction of the barrier in the occupied Palestinian territory, including East Jerusalem, was actually contrary to international law. And it emphasized the principle of the right of peoples to self-determination and prohibition of acquiring a territory by force. Yeah? And then if you have to argue also, another one that comes into mind is the UN Security Council 242, which happened in 1967, and also Resolution 338, which happened in 1973. And by way of case, to support what I'm saying, these resolutions called for Israel's withdrawal from territories occupied during the 1967 Six-Day War. And they've actually played a crucial role in framing Israel-Palestinian conflict and efforts to achieve a peaceful settlement. In terms of principle, this resolution underscores the principles of what they call inadmissibility of the acquisition of territory by force, the right of all states in the region to live in peace and security, and the importance of a just and lasting peace in the Middle East, as it says. And then you may also want to look at the International Criminal Court, what they call the ICC investigation into Palestinian territories, which happened in 2020. Yeah, if you have to argue that, then you must understand that ICC announced its intentions to investigate potential war crimes in Palestinian territories, including actions of both Israel and Palestinian actors. And in terms of principle, you would argue and say that the case raises issues related to individual criminal responsibility for violations of international humanitarian law and international human rights law. Yeah, and basically it underscores the principle that serious violations of international law should actually be subject to investigation and even accountability. Yes, and then if you have to argue again in terms of what they call the Oslo Accords, which happened in 1993 to 95, by way of play out, the Oslo Accords were actually a set of agreements between Israel and Palestine Liberation Organization, which we call PLO, that aim to establish a framework for the resolution of Israel-Palestinian conflict. Yeah, and in terms of principles, the Oslo Accord highlighted principles of self-determination, mutual recognition, and the pursuit of a peaceful settlement through negotiations. And it appears that all things are actually on paper, but the practicability of it becomes a question. Either the will is not there, or the heart, or I don't know. And then international humanitarian law and the so-called Fourth Geneva Convention. In terms of principle, these legal frameworks prohibit the transfer of an occupying power, occupying power civilian population into an occupied territory, safeguarding the rights of civilians in terms of conflict and emphasizing the importance of protecting non-combatants and ensuring their access in terms of humanitarian assistance, So again, I'll argue that the development of the Palestinian-Israel conflict has actually involved, no doubt, a complex interplay of legal principles in terms of international case law, in terms of diplomatic efforts, and these key principles, as I said, include the prohibition of the acquisition of territory by force, the right for self-determination, the protection of civilians, the pursuit of peaceful settlement, and legal cases and opinions have actually provided a guidance in terms of the application of these principles to specific contexts in terms of the conflict, but also challenges in terms of achieving what they call a just and lasting resolution to this issue. So we may want to say that if we're to continue our discussion in terms of international case law, we may bring in a little bit of some others that I may not have mentioned earlier. If you look at the United Nations General Assembly Resolution 194, which happened in 1948, this particular resolution basically addressed the issue of what they call the Palestinian refugees in terms of their right to return to their homes. While it is a General Assembly resolution and not a binding treaty or judgment, it remains significant in the context of the Palestinian refugee issue. And in terms of principle, Resolution 194 reaffirms the principle of the right to return for Palestinian refugees, a matter central to the Palestinian native and even their claim to justice and compensation. And then if you argue in terms of the status of Jerusalem and the United Nations, then we will look at it in terms of the principles that it brings up in terms of international law. The status of Jerusalem, for example, has actually been a contentious issue. So while both Israelis and Palestinians claiming Jerusalem as their capital, the international legal principle involved here is that the importance of protecting the unique religious and even cultural significance of Jerusalem, as well as the principle of the city's status as a final status issue to be resolved through negotiations. That's the option that perhaps is the best sought after by people who have tried to create some kind of understanding. And then the recognition of states and self-determination as a principle in terms of international law, which recognizes the right of peoples for self-determination and including establishment of their own states. This has also, lent a question of recognition in terms of statehood, which has actually been central to what they call the Israel-Palestinian conflict, with efforts by Palestinians to gain recognition as a state in international organization. If you have to argue again in terms of what they call diplomatic efforts and peace processes that may have ensued, then in terms of principle, internationally, we could argue that the pursuit of peace and the use of diplomatic means to resolve these conflicts are fundamental principles of international law, and various peace initiatives and negotiations, including the Camp David Accords, the Madrid Conference, and the Quartet of the Middle East, have actually aimed to promote peace, security, and even cooperation in the region. Whether or not there are substantive results is a question of debate. But perhaps also, importantly, is the human rights law that is involved here. In terms of international human rights law, the question here is in terms of including what they call the Universal Declaration of Human Rights, which plays a role in addressing human rights abuses and the protection of individuals in terms of conflict zones. Human rights organizations and reports have actually documented alleged violation by both Israeli and Palestinian parties in terms of this conflict. And therefore, that is something, again, that is of serious interest. And perhaps also important to notice that the Israel-Palestinian conflict is definitely marked, as I said, by a complex interplay of international legal principles in terms of international case law, in terms of political negotiations, and the challenge basically lies in applying these principles to a deeply rooted and highly contentious conflict that involves the issues of territory and refugees and self-determination and the right of both Israeli and Palestinian populations, achieving a just and lasting solution to the conflict. My opinion remains a top priority in international diplomacy. Please understand that. We have no shortcut to that. I think it's a question now of living together, side by side. My name is Isaac Christopher Lubogo. Consider that Volume 1 of International Law in as far as the debate between Ukraine versus Russia and Israel versus Palestine. God bless you and thank you. Find our books at lubogo.org, suegeneslaw.com, and go visit our YouTube, subscribe, and let's change the world. God bless you.